Okay, hello dear students, welcome to this video lecture series on behalf of Project SATHEE. Today we are going to continue with our discussion on general exceptions. In the last class, we discussed certain general exceptions like judicial acts, like mistake of fact, like justification and all. And today we are going to continue our discussion. This is the third lecture of the second module. I am Dr. Animesh and let's begin with our discussion. Okay, first things first. To give you a background of what we're discussing, that we were discussing about general exception. A general exception means something that eliminates criminal liability. Means a person, even though he has done a criminal act, his act has a criminal uh, repercussion. The person will not be punished because of a circumstance that exists. And in the same link, we'll discuss today's exception is accident. Now, accident, the term accident comes from another term, accidere, which means chance or befall. If something happens by chance, then it is called accident. Now, to call something accident, we have to understand two things. Number one, it is unpredictable and unpreventable. If something is unpredictable, obviously that is called accidental. If something you know is going to happen, then it is not accident. Similarly, if you are in a position to interpret or prevent it by ordinary caution, then it is not considered accidental. If something is predictable or preventable, it is not accidental. Accidental means something which cannot be prepared, which cannot be predicted and cannot be prevented, which we cannot protect against. That is called accident. Similarly, there is another term, misfortune. Now, accident and misfortune are two terms which are generally used interchangeably, but there is a small difference between it. Now, see, accident can be a happy accident, like the discovery of penicillin, the discovery of radium. Now, those things are accidental, means they were not predicted or prevented, but they happened anyway. But if the repercussion of accident may be good or bad, sometimes accidentally good things happen only. Misfortune are those accidents for which there is some evil repercussion. Obviously, the thing that we are concerned about is in law is something that evil happens because of that accident. So, what we call it misfortune. Misfortune means something that has an evil consequence, but nonetheless it is accidental. Now, see, if somebody wants to take this plea of accident, that see, a crime happened, a criminal consequence happened, but I did not intend it to happen. मेरी कोई गलती नहीं है. It was not my intention to cause this harm. In that case, we call it obviously accident. But there are few requirements of it. The provision in Bharatiya Nyaya Sanhita says that nothing is an offense if the act is done without criminal intention or knowledge. An accident is accident only when you do not have any criminal intent or knowledge. If you have some criminal intent, obviously, if you have knowledge of what is going to happen, it is not accidental. We started with this notion that if something is predictable or preventable, then it is not accident. Okay. To give you a context, very simple. That people suppose there is a road traffic accident. If there is a traffic accident and police comes to know that the person who was driving the vehicle and the person who got run over, they were having some kind of enmity, then obviously police will investigate this angle that whether this accident is actually not an accident or it's actually a crime. Many a times you must have seen in movies and TV that people, when they actually give someone a contract to kill someone, they say make it look like an accident. Means if it looks accidental, the police will not prosecute us. It should look accidental that this incident happened because of something which was unpredictable and unpreventable. But the first thing the police looks is that whether there is a ground for presuming that the person who has caused that accident or anybody related to him might have had the motive or might have had the intent or knowledge about the identity of the person who has been killed, or whether he gained something out of it. Now, there is a fundamental rule you must have seen CID episodes in which they they did do a differential diagnosis on the basis of facts, and they say that okay, who was supposed to gain maximum from this death? Obviously, then the first thing that we have to understand is that there must be no criminal intent or knowledge. If I was doing something intentionally, it is cannot be considered accidental. Like I'll give you an example. Suppose two players are playing, two persons are playing. Suppose there is a game of cricket, and I, as a bowler, I have the intent to harm physically the batsman. That's why I am throwing. I am giving beamers, means directly ball aiming towards the body of the batsman again and again, because I have some enmity. We had a heated discussion, and after that I have started bowling in such a dangerous way that is not allowed by the game. So in that case, suppose a person dies, now the question will come whether there was a criminal intent or knowledge. If the answer is yes, if the person is the bowler actually wanted to hurt batsman, his intent was to hurt him by any by hook or by crook. In that case, it will be considered a crime, and the person will not get the benefit of accident. Okay. Then second part. Again, this is very interesting. That if the act that has been committed A was a lawful act and it was done in a lawful manner and it was done by lawful means. Now, simply understand that accidents are, we call a particular act an accident only and only when the person who claims the accident was doing a lawful act. In the sense, I'll give you 4 or 5 examples and you will decipher which one is accidental. Let's say I had a enmity with someone. I had enmity with Mr. A. Now I went to kill Mr. A and I fired a bullet towards Mr. A. And Mr. A actually moved and the bullet went to Mr. B and killed Mr. B. Now the question is whether my act is accidental or not. The court will say no, your act is not accidental. Why? Because you were not doing a lawful act. For claiming the benefit of accident, for me to say that okay, accident happened, it happens actually many times. So people, there are accidentals that suppose my car was there and the brake stopped working and I hit someone. That's an accident. That's the definition of accident. A train accidents happen. Sometimes the two trains they collide. Accident happens, but the person who, because of whose act that particular unlawful consequence happened, means somebody is dead, somebody has been harmed. The first question that will be asked whether he was doing a lawful act or not, means whether he was committing a crime. Suppose मुझे एक घर में चोरी करनी है और मैं गलती से दूसरे घर में घुस गया, तो मैं कह सकता हूँ कि सर नहीं, मैं तो एक्सीडेंटली घुस गया दूसरे घर में चोरी करने, मेरा तो ए ब्लॉक में चोरी करना था, मैं बी ब्लॉक में चला गया. Now it's not something that will be appreciated by the court. You must be doing a lawful act. Then there are ways to do a lawful act. There are ways to do. There is a way to do a lawful act. Like I'll give you an example. Very simple. Suppose protest is a lawful act. Protest is a lawful act, and it is a very strong democratic custom that whenever we don't like anything about the decisions taken by the government or any authority, we protest. So there is a way to protest. There is a lawful manner. Suppose I am protesting, and while protesting, I am not causing any public discomfort. किसी का रास्ता नहीं रोका मैंने, कि कोई सड़क जाम नहीं किया, कोई चक्का जाम नहीं किया. So obviously, if something happens still because of my protest, in that case, suppose I was protesting and achanak because of anything, because of the sloganeering we are taking, something happened. Somebody got distracted and somebody got hurt. In that case, I will not be held liable. But if my manner was not lawful, Suppose I was trying to do protest by blocking a particular area. Okay, so I blocked a particular road, and an ambulance came. An ambulance came, and because of the blockade that we have put, the ambulance failed to take the person who was dying to hospital on time, and the person died. Now the question is whether I can say that this was accidental. No, because I was not doing a lawful act by lawful manner. If you want to protest, you can protest without causing public nuisance. So in that case, it will not be considered lawful manner. In a lawful manner, it's very important that you are doing lawful act in lawful manner. I'll give you another example. Suppose I am entitled to a scholarship. एक scholarship मुझको मिलनी चाहिए सरकार के सारे क्राइटेरिया में मैं आता हूँ. पर मैंने क्या किया, उस स्कॉलरशिप को पाने के लिए एक फोर्ज डॉक्यूमेंट लगा दिया. Suppose I was supposed to get a document, and that document was unavailable. लेट्स से डॉक्यूमेंट ऐसा हो गया कि वो डॉक्यूमेंट मेरे पास नहीं था. मैंने क्या किया, फॉर्ज डॉक्यूमेंट क्रिएट किया और जमा कर दिया स्कॉलरशिप के लिए. आई वाज अदरवाइज एलिजिबल फॉर स्कॉलरशिप, but nonetheless this particular submitting of a forged document, a wrong document, made my act unlawful, because I was doing a lawful act, because I was seeking scholarship which I deserved, but the manner was not lawful because I submitted a forged document. Then we have lawful means as well. Means the things that I employ, things that I use. Now there is a very famous example in that context that there is a woman, and she has a very naughty child. That child is creating nuisance. So the mother throws an iron bar towards that child, and that child, who is very habitual in that particular way, he dodges that iron bar. वो हट जाता है, and that iron bar hits another child. Now the question is whether the mother is criminally liable. You can say कि sir, she was trying to discipline her child. That is a lawful act, and it is lawful to throw something or to physically hurt a child sometimes in moderation to discipline that child. But whether throwing a dangerous thing, like an iron bar, towards that child was lawful means, the answer is no. What means that you have also becomes very important. What means you have employed? And it cannot be considered accidental. Sometimes you can be doing a very, like I'll give you an example. Suppose I have a house and I am threatened by those who are trespassing. मतलब मेरे घर में कभी कोई घुस जाते हैं. तो मैंने क्या किया, मैंने अपने गार्डन में लैंड माइन्स लगा दी. लैंड माइन्स पैर पड़ा और बस उसके बाद व्यक्ति अलग अलग हो जाता है. तो सपोज protecting your house is lawful act, and causing some hurt to those who are accidentally or who are coming to your house but trespassing into your property is also fine. But landmine is not lawful mean. If you would have kept a dog, if you have fenced your house, it would have been correct. If you have positioned a guard outside your home, perfectly all right. But you cannot have landmines. That is not lawful means. तो मीन्स मस्ट बी लॉफुल. सपोज मान लीजिए आपने घर में कुत्ता रखा, आपके घर में चोर घुसा, कुत्ते ने उस चोर को काट लिया, आपकी लाइबिलिटी है? देयर इज नो लाइबिलिटी. यू विल से कि सर मेरा एक्ट लॉफुल, मेरा मैनर लॉफुल, मेरे मीन्स लॉफुल. लोग घर की प्रोटेक्शन के लिए कुत्ता रखते हैं, मैंने रखा, उसने काट लिया चोर को. बट सपोज आपने लैंड माइन्स बिछा रखे, आपने स्नाइपर बिठा रखा कि वो घर में आए उसे गोली मार देना. नाउ दैट इज समथिंग दैट वी कॉल unlawful means. So in order to say that a particular act is accidental, it is required, it is must that there must be a lawful act by lawful manner and lawful means. यानी you must not be doing anything illegal. आप जो काम कर रहे हो बच्चों, वो काम ठीक चल रहा हो. If you are like, suppose I am driving on road, okay, and suppose I was driving while being intoxicated and I hit someone. Now the question is whether my liability will be there, whether I can plead accident. The court will say you cannot plead accident. while driving is a lawful act, but driving while intoxicated is not lawful manner. शराब पी के गाड़ी नहीं चला सकते. So that is something that will hold me liable. ना बाकी बड़े बड़े लोग नहीं भी liable होते हैं कई बार, लेकिन nonetheless, generally if you are drunk driving, you will be held liable for any harm that you have caused. You cannot say कि sir accidental था, अचानक सामने आ गया. No. Court will say because you were intoxicated, it took away your capability to respond in a very prompt way, and because you were intoxicated, it is not accidental, because obviously it could have been prevented if you were driving sober in a correct way. Now see, sometimes people sleep while driving the car. That happens. Like Rishabh Pant was sleeping when matlab he fell asleep while driving, so accident happened. But everybody says it is the accident because that can happen to anyone. There is no way to prevent it. He was doing a lawful act, lawful manner. Lawful means he was within the speed limit and everything. But it happened nonetheless. So it is accident. But if he was drunk, in that case, he would have been held liable. If someone else would have been harmed, so liability ban jati. Last not but the least, proper care and caution. If you are negligent, it is not accident. In the very beginning, in a previous class, we were discussing about negligence. Now, negligence is something that can convert an accidental act into an intentional act or a non-accidental act. Like I gave you an example in that class that suppose मेरे पास एक कार है और उस कार को मैंने 5 साल से सर्विसिंग नहीं कराई, चेक ही नहीं कराया कि ब्रेक ठीक है नहीं है क्या है. द कार रिक्वायर्ड सर्विसिंग मेंटेनेंस, और मैं उस कार को चला रहा हूँ, ब्रेक फेल हो गया, मैं किसी को भिड़ गया. नाउ द क्वेश्चन इज वेदर माय लायबिलिटी इज देयर. द आंसर इज यस, माय लायबिलिटी इज देयर because I failed to take proper care and caution. I failed to take the proper care and caution. So it is not accidental. This could have been prevented by proper care and caution. Like I'll give you the example of one of the biggest problems we face as a community, specifically to the people of Madhya Pradesh, Bhopal, that is gas tragedy, Bhopal gas tragedy. Now, in Bhopal gas tragedy, if you have watched that very interesting The Railway Man, it's a series also on Bhopal gas tragedy. And obviously, the official report of the government, if you will read, you will find that there were many, many lapses on the part of Union Carbide. The people who were responsible for running that plant were given multiple memos, multiple cautions they have been given कि भाई आप ये जो कर रहे हैं इसमें खतरनाक है, खतरा है, ऐसा प्रॉब्लम है, ऐसा प्लांट में ऐसी समस्या है. They failed to take care of anything. They simply neglected those warning signs. So once you neglect warning signs and something happens, that is not accidental. If something is not accidental, if you could have prevented it with proper care and caution. If you are negligent, it is not accidental. It simply says आपका क्रिमिनल इंटेंट भी नहीं होना चाहिए, आप कर भी लॉफुल काम रहे हो, और आप नेग्लिजेंट नहीं होने चाहिए. You must act proper with proper care and caution. आप बिल्कुल सड़क पर बिल्कुल सही से गाड़ी चला रहे हैं, स्पीड लिमिट भी है, you are sober, you are driving correct on the correct side of the road, still accident can happen. सामने से अचानक ट्रक वाला आ गया, आपने गाड़ी घुमाई, किसी को टक्कर लग गई, है ना. यू मस्ट हैव सीन कि जानवर को बचाने में और बच्चे को बचाने के लिए पीपल, है ना, there are accidents all the time. Sometimes lapse of judgment is there, and number of reasons can be there. But if you are taking proper care and caution, you are not negligent per se. Everything is not in our limit. Everything is not within our control. But if it happens without proper care and caution, like the incident in Chernobyl, there is also a very interesting HBO series on Chernobyl. It's named Chernobyl. It's one of the finest miniseries that there is, and if you have not watched, please go and watch Chernobyl. In Chernobyl, also, what happened? They were negligent. That was one of the biggest accident that ever happened Some people call it the reason behind fall of Soviet Union, because a few nuclear engineers were negligent in their behavior, in their action. They were negligent in the sense that they failed to observe the proper safety procedures. If you are doing like that, your liability will be there. But if you are acting properly, even if someone dies, like cricket fields, recently, a few years back, a very promising batsman of Australia, Phil Hughes, he died because a bouncer of a particular bowler seen a bot. It hit in the head of the Phil Hughes. He fell and he died. Now, what is the criminal liability of seen a bot? There is no criminal liability. नहीं लाइबल है, क्यों नहीं लाइबल है भाई? इसलिए लाइबल नहीं है क्योंकि उसकी कोई पहले तो क्रिमिनल इंटेंशन नहीं थी, दूसरा वो लॉफुल एक्ट, लॉफुल मैनर, लॉफुल मीन्स कर रहे थे, और उन्होंने बाउंसर डाली जो कि एक एक्सेप्टेड वे ऑफ बॉलिंग है. अगर बॉलर ने बाउंसर डाली, बैट्समैन के हेड पे लगी, बैट्समैन की डेथ हो गई, परफेक्टली ऑलराइट, देयर इज नो लायबिलिटी. पर बैट्समैन ने बैट चला दिया, बॉलर को सर पे लग गई, बॉलर मर गया. अब यहाँ पे वो नहीं कह सकता कि सर खेल में चोट लग गई, बिकॉज बॉलर bowls towards the batsman. Batsman does not throw bat towards the bowler. है ना? तो ऐसा होता है. ऐसा नहीं कि आपने स्टंप उठा खड़ करके उसको अंपायर को पीट दिया और आप कह रहे कि सर खेल में चोट लग गई. नहीं. Obviously, if it is accidental, it's accidental. Brake fail हो गया, a car slipped, n number of things happen, and n number of accidents happen. You can go and watch all that. There's a whole series of fatal. There's a whole movie series about those freak accidents that happen. Okay, so proper care and caution is something that is needed. Okay, moving on. So I hope accident much is clear. Let's talk about infancy. Infancy means obviously bacha, chota bacha. So child, so in generally in our criminal law, in BNS we divide children from in three criteria. In three subdivisions we divide them. First is child below 7 years of age. They are called doli incapax. Doli incapax means incapable of committing crime. Very simple. बच्चे मन के सच्चे. If a child is below 7 years of age, that child cannot have requisite intent to commit a crime. So any act done by a child below 7 years of age is excusable. Excusable in the sense that no liability will be there. छोटे बच्चों की कोई criminal liability नहीं होती, क्योंकि they have not developed a sense of right and wrong. What is right, what is wrong, they do not know. That is why there is no criminal liability for a child below 7 years of age. And it makes sense. Now, child above but below 12 years of age. 7 से 12 में क्या है बच्चों? The law says, the Bharatiya Nyaya Sanhita says that it depends on the maturity of the child. Like there are some offenses which a child can do while being 7 to 12 years of age, but there are some offenses which the child is incapable of doing. Like I'll give you an example. Suppose theft. Theft है, चोरी है. Whether a 10-year-old child can steal something? Answer is yes. Because by 10 years, a child comes to know what is mine and what is not mine. He'll have a sense of what property is his property and what property is the property of another. Whether a child can hurt someone? Yes, बच्चे लड़ते हैं. 10 years old, 11 years old child, they can fight and they can hurt each other. But when it comes to more nuanced offenses, और गंभीर offenses की बात करें, whether an 11-year-old child can be liable for sedition, for waging war against India, आप उसको समझा सकते हैं कि भाई भारत के खिलाफ युद्ध क्यों करना है आप? Whether he will be clear on the idea of what constitutes a nation and why somebody should fight against the nation? Answer is no. You cannot prosecute an 11-year-old child for waging war against India. You cannot prosecute an 11-year-old child for counterfeiting currency, because the expertise that is there, that is required in counterfeiting currency cannot be there in 11-year-old child. Can you punish a 10-year-old child for rape? No, answer is no, because before puberty, that person is incapable of having sexual urges. So rape is out of the question. Whether a child can be considered liable for forgery. Forgery, I believe we all have signed our parents' name in our school diaries or something. So that happens. But nonetheless, you cannot punish them for that because there is no sufficient maturity to understand the consequence of it. Why we do not punish children is they do not know the full consequence of their action. Some smaller and petty offenses, they know that I am hurting someone or I am stealing property, theft, robbery, all these things I understand. You know, but more nuanced offenses, bigger offenses, I do not. That is the logic. Uh, we say that a child above 7 but below 12 years of age, if the child has maturity, sufficient maturity to understand what he is doing, in that case, the child can be prosecuted, else he cannot be prosecuted. Now, child above 12 years of age are fair game, means they can be prosecuted under Bharatiya Nyaya Sanhita. But all these provisions, 7 से above, 12 से 18, ये सारे जो प्रोविजन है बच्चों की लाइबिलिटी के बारे में, all these provisions have been rendered completely futile. Completely, they have been uh, rendered false or inoperative by the Juvenile Justice Care and Protection of Children Act of 2015. Even before that, we had a JJ Act, but it's this new JJ Act, 2015 JJ Act. JJ Act, we call it, Juvenile Justice Act. Now, under this Juvenile Justice Act, any child below 18 years of age, that child cannot be punished. It has an exception that the child below above 16 years of age, if that child is has committed some heinous crime and the juvenile court considers him sufficiently mature, then that child above 16 years of age can be prosecuted as an adult. But that is a unique case. In all other cases, a child below 18 years of age will not be subjected to normal criminal court. They will be taken to the juvenile board, and the juvenile board cannot punish a child. The idea of punishment is not there for the children who are for the children who are below 18 years of age. What we can do, maximum we can send them to correctional homes. Now correctional homes and prison are different. They are not the same, and they are maintained in a very different way by the government. So a child below 18 years of age can be sent to correction home for a maximum period of 3 years. Uh, you must have heard that Pune Porsche case, है ना? There was a huge outrage. खूब लोगों ने बवाल काटा कि भाई आपने वो बच्चा, वो 16-17 year old child था and he ran over some people, और उसको फिर ऐसे लिखवा करके बेल दे दी, कैसे हो गया, पैसा बहुत था. अगर बच्चों उस व्यक्ति के पास बिल्कुल पैसा ना होता ना, तो भी लॉ के हाथ में कुछ भी नहीं था वहां. That particular child was a juvenile, and as a juvenile you cannot send that juvenile to jail. All juveniles are supposed to get bail. They are that all offenses done by juveniles are bailable, in the sense that you cannot keep them in custody for a long period of time. You cannot send them to prison. For their own protection, they can sometimes they can be sent to correctional homes, but they cannot be sent to jail. आप उनको जेल नहीं भेज सकते, आप उनको करेक्शनल होम्स भेजेंगे, और उनको पनिश नहीं किया जाता, उनके सिर्फ करेक्शन की बात होती है. उनको करेक्शन कैसा होगा? तो 18 साल से कम के बच्चों की पनिशमेंट का आइडिया ही खत्म हो गया है विद जेजे एक्ट. Now the idea of punishment is one. The idea of reformation is something that is very important. अगर एक child juvenile है तो juvenile है फिर. Recently, few days back, Supreme Court came to know that a particular person was in jail when he committed crime. He was 14 years old. Supreme Court set aside the punishment. Supreme Court immediately released that particular child because the Supreme Court said that we were not aware, the courts were not aware that this person was a minor at the time of committing the crime. If he were minor, there is no point of punishing him. The maximum what you can do is to send him to correctional homes, and he was already there in jail for 25 years. The Supreme Court immediately set aside the sentence and released that particular person. Because आप crime कब करते हो ये बहुत important है. अगर if you are a child when you committed the crime, and child means below 18 years of age. If below 18 years of age आप हैं तो आपको ordinary courts में punish नहीं किया जाएगा. You cannot be punished in ordinary courts. You cannot be punished at all. So JJ Act prevail करता है भारतीय न्याय संहिता में. भारतीय न्याय संहिता कहते हैं कि भाई 7 to 12 years child maturity देखेंगे, कुछ नहीं देखेंगे. That child will be sent to juvenile justice board, juvenile board, and juvenile board will determine whether that child uh, has to be sent to correctional home. That child can be admonished. उसको डांट करके छोड़ देना है, ऐसे लिखवा करके छोड़ना है, क्या करना है, that juvenile board will decide. It cannot be that public outrage हो गया, अरे कैसे हो गया. Nothing that could have been done. हाँ? ऐसे लिखवा के छोड़ते तो बिल्कुल नहीं. वो माइनर था इसलिए ऐसे लिखवा करके उसे छोड़ना पड़ा बोर्ड को. इसलिए नहीं कि वो पॉर्श चला रहा था या बहुत अमीर था. गरीब भी होता. 15 साल का बच्चा जो है, आई कम फ्रॉम बिहार, वहां पे शराब की तस्करी करते हैं. स्कूल के बच्चे बैग्स में अल्कोहल लेकर के जाते हैं. वो ऑब्जर्व दिस. So suppose police catches them, they'll be sent to jail. The answer is no. Immediately they'll take them to juvenile board. Juvenile board will say what you can do. Even if the juvenile board finds them guilty, the juvenile board will send that child to correctional homes. And maximum 3 years correctional home you can put a child. है ना. ये जो 16 से 18 है ना, that above 16 years of age, if the child has committed hideous offense, that child can be tried as an adult. वो भी निर्भया इंसिडेंट में, that one of the rapist Afroz, he was 17 at the time, and he was the person who did the most heinous crimes against that particular girl, and he was sent to correctional home for 3 years. After 3 years he was released, and his identity was changed, and he was given a fresh identity to live. The people outraged, but this is how the law works. A juvenile is given a second chance in all the cases. Okay, this much is clear. Let's talk about insanity. That is the most interesting part that we have to discuss today. Unsoundness of mind. Now, unsoundness of mind in simplest sense means that if the person's brain, if his rational faculties are not working properly, दिमाग ठीक से नहीं चल रहा है. So medical insanity is something that a psychiatrist or a psychologist will say that this person is having some mental issues. But whether the mental insanity is in absolute defense, whether it is medical insanity is in absolute defense, see, this much is clear that insanity is a very solid defense. You must have seen people taking this defense in movies and TVs that, okay, the person while committing the crime was insane. So if the person was insane, no liability will be there. Insanity is a very solid defense. So if a person has committed a crime while being insane, that person is not punished because insanity is sufficient punishment. The logic behind not punishing that person, not punishing a person who is insane, is because insanity itself is a punishment for the person. अगर वो व्यक्ति मानसिक रूप से अस्थिर है तो यही उसके लिए दंड है, उसको दोबारा दंडित नहीं किया जाता है ना. ओके, so that is medical insanity, something very important to understand. अब बच्चों यहाँ पे 2 टर्म लिखे हैं मैंने स्लाइड में, मेडिकल इंसैनिटी एंड लीगल इंसैनिटी. अच्छा, बिफोर दैट वी मिस्ड वन पार्ट, डिटर्मिनेशन ऑफ एज इन मैटर्स रिलेटेड टू जुवेनाइल. अच्छा, एज हम डिटरमाइन करते हैं बच्चों. सिंपल रूल है, वी सी स्कूल सर्टिफिकेट्स. 10th का सर्टिफिकेट इज वेरी इंपॉर्टेंट डॉक्यूमेंट. 10th के सर्टिफिकेट से आपकी एज डिटरमाइन होती है. 10th का सर्टिफिकेट अवेलेबल नहीं है, बर्थ सर्टिफिकेट कैन आल्सो बी यूज्ड. But if no certificates are available, then bone ossification test is done. Bone ossification test means हड्डियों की जांच करेंगे डॉक्टर और बताएंगे कितनी एज एक व्यक्ति की है. ठीक है, this is how determination of age is done. Okay, and if there is an ambiguity, सपोज बोन एसोसिएशन टेस्ट ने कहा कि बच्चा 17 से 19 तक का है, तो वेदर दैट चाइल्ड विल बी कंसिडर्ड जुवेनाइल और नॉट जुवेनाइल, द कोर्ट से जुवेनाइल माना जाएगा उसको. इफ देयर आर एविडेंसेस which says that this child is juvenile, while there are some evidences which say this is not juvenile, so the court will give a beneficial interpretation. यानी कि कोर्ट क्या करेगी, उस यंग बच्चे को फायदा देने का प्रयास करेगा जेजे एक्ट का, जेजे एक्ट का लाभ देने का प्रयास करेंगे. इट्स अ बेनिफिशियल लेजिस्लेशन. जेजे एक्ट का पर्पस है छोटे बच्चों को या माइनर्स को प्रोटेक्ट करना. तो अगर क्लियर नहीं है कि कोई माइनर है या नहीं माइनर है, बट इस बात की अच्छी संभावना है कि हो सकता है ये माइनर हो, तो फिर उसको जेजे एक्ट से ही ट्रीट करते हैं. ओके, नाउ कमिंग ऑन टू इंसैनिटी. मेडिकल इंसैनिटी सिंपली मींस दैट देयर इज समथिंग रॉन्ग विद द ब्रेन. But just because something is wrong with the brain, the person will not be exempted from criminal liability, because there is something wrong with everyone's brain. Nobody is perfectly sane. We all have our small insanity. You might have some phobias. People have phobias. They have fear of water, fear of heights, fear of crowds, fear of insects, fear of snakes. N number of phobias are there. Phobias are irrational fear. So if I have irrational fear of something, then it is called phobia. So phobia is also that there is something wrong with my brain. Then we have some people might have anger issues. That is also a form of insanity. Some people might have obsessive compulsive disorder. That is also you. Some people are neat freaks. Some people are grammar Nazis. Some people are they have very extreme compulsive behavior. Some person might be depressed. Some person might have any number of mental issues are there. So having a mental issue is not insanity. Insanity, it becomes a defense in criminal law when, because of that insanity, understand very carefully, if because of that insanity the person who committed a criminal act was unaware, or he was unaware that his act is either wrong or contrary to law. If because of that insanity he was completely unaware about the nature and consequence of his action, or that his act is wrong or contrary to law. This is very important to understand. Medical insanity अगर किसी में है तो a person might be insane in some respect and he may be sane in other respects. जैसे मैं आपको एग्जांपल देता हूँ बच्चों, बहुत सिंपल सा. आप सब लोगों ने वो मूवी देखी होगी, लगे रहो मुन्ना भाई, है ना, in which the person, so the primary character, Sanjay Dutt character Munna Bhai, he reads about Gandhi so much that he starts hallucinating that Gandhi is in front of him under all circumstances. And whenever he calls Gandhiji, Gandhiji comes. So that is what it can be considered as. It is insanity. Obviously, it's insanity. He's hallucinating a person who is not in existence. So the person, Sanjay Dutt, was insane in respect of that particular area, in that particular situation. But he was sane in respect of everything else. Suppose उसमें लगे रहो मुन्ना भाई में, suppose आप और मैं किसी को hallucinate करते हैं कि कोई है हमारे साथ. Suppose somebody is walking right behind us, right beside us, है ना, बाएं से चल रहे हैं, दाहिने से चल रहे हैं कोई हमारे, जबकि वहां पे है नहीं, but I am hallucinating that somebody is there. Now suppose a motorbike is coming at full speed and I believe that that motorbike will simply hit the person who is walking right beside me, गांधी जी लेट से. तो मैं क्या करता हूँ, आगे बढ़ता हूँ और मोटरसाइकिल वाले को धक्का दे देता हूँ. तेजी से आ रहा होता है, उसको धक्का दे देता हूँ ताकि गांधी जी को कुचल ना पाए, गांधी जी को चोट न लगे. Now this is situation number 1. Now situation number 2 is कोई गांधी जी को नहीं बुलाया मैंने, मेरे से किसी की एनिमिटी थी, मैंने पीट दिया उसको. Now in both these cases, situation number 1, situation number 2 में, situation number 1 में that person will not be held liable. In situation number 2, he will be held liable because here, in the first instance, what he did because of the insanity. Because of that particular insanity, he did that act. In second case, that insanity he had and the act he done were separate, where those actions were not related. तो मेडिकल इंसैनिटी का मतलब आपके दिमाग में कुछ गड़बड़ी, समथिंग इज रॉन्ग विथ योर ब्रेन, बट देयर इज रॉन्ग विथ एवरीवनस ब्रेन. So whatever is wrong in your brain, if that actually led to the act that you have done because of insanity, जैसे there is a very famous मैग्नॉटन्स केस कहते हैं हम लोग, बहुत पुराना एक केस है इंग्लैंड का, very famous case. What happens that a person started this fear or this had this phobia, that he had this delusion that Prime Minister of Britain is coming to kill him. He had this delusion. He was in delusion. He was otherwise very much sane, but he had this particular delusion. And because of that, he constantly thought, now Prime Minister is coming to kill me, Prime Minister is coming to kill me. So when the Prime Minister was actually visiting his hometown, he became insane so much, his delusion became so heightened that he took a gun and thought, before the Prime Minister kills me, I will kill the Prime Minister. So he goes and he fires bullets towards the Prime Minister. One of the people who were accompanying Prime Minister, he was shot and he died. Now the question is, whether his criminal liability is there or not. So the court said कि because of his insanity, क्योंकि उसके दिमाग में गड़बड़ी थी, he thought what he did was to defend himself. Because that person was insane, what he did, he thought in his mind was to protect himself. But that was not actually the case. But he fired that bullet because of his insanity. Because he was unaware that whether his actions is wrong or contrary to law, because he thought his action to be justified. तो ये बच्चों बड़ा इंपॉर्टेंट है. मेडिकल इंसैनिटी का मतलब देयर इज समथिंग रॉन्ग विथ योर ब्रेन, बट ऑल मेडिकल इंसैनिटीज आर नॉट लीगल इंसैनिटीज. In order to be legal insanity, it will have to be proved कि जो criminal act इसने किया है और जो insanity इसकी है, दोनों आपस में गहरे related हैं. He was not aware about the consequence or legality of his action. Suppose there is a person who is generally insane, पागल खाने में भर्ती है. So one day he comes to know that when he got insane, his wife married another man. Now what he did, he jumped out of that, he broke out of that particular mental asylum, went to the husband of his new husband of his wife, and he killed that man. Now in that case, we can obviously understand, we can see from his conduct that while he was generally insane, but he was sane in this particular act. Because he was acting on vengeance, he knew what he was doing. He was fully aware that he is acting on vengeance because he is trying to kill. He is motivated by jealousy, and because his wife married another man. So he went there and he killed his wife's new husband. Now his action, although that person is generally insane, but इस एक्ट के रिस्पेक्ट में वो सेन था. तो कोई व्यक्ति अगर जनरली इंसेन हो, ऐसा नहीं कि वो हर एक्ट के रिस्पेक्ट में इंसेन है. इंसैनिटी को हम हमेशा किससे जोड़ते हैं? एक्शन से. आपके एक्शन से हमको पता चलेगा कि whether the person's medical insanity played a role in his act or not. If I am generally very sane, but I am insane about a particular thing, and I committed an act in pursuance of that, मेरे हो सकता है कोई delusion हो, कुछ hallucinations हो, कुछ phobias हो, a number of things can be there. So if I acted because of that, suppose I have है ना, उसको कहते हैं एंड्रोफोबिया, कुछ डॉग्स का फियर है मेरा, बड़ा खतरनाक फोबिया है मुझे डॉग्स का. मुझे लगता है अगर डॉग है तो मुझे काटने ही वाला है. सपोज आई सी समवन्स डॉग विद देम, and because of my phobia I become so panic, I get so much panic that I know that this dog is going to bite me, I am going to get rabies, and I simply I have a gun, so I take out my gun and shoot that dog. Now that dog has died, the owner of that dog will file a case against me because I destroyed that person's property. I can go and plead in the court, okay, sir, because of my phobia, I killed that dog. Answer, whether I'll be protected by law? Answer is yes. Because I thought this dog is going to kill me for sure. So I acted in self-defense in my mind, which was not actually the case. That dog was very docile. He was not going to attack me. That dog was not about to attack me. But still, because of that irrational fear, I killed that dog. So whether my liability will be there, answer is no. But suppose I have fear of dog and I killed a man because of some personal enmity I have. Whether I can say कि सर because मुझको dog का phobia है तो मैंने इस आदमी को मार दिया randomly. The answer is no. So medical insanity becomes legal insanity when that medical insanity leads to commission of an act. And because of that medical insanity, a person is incapable of knowing कि जो मैं कर रहा हूं वो गलत है. मुझको ऐसी इंसैनिटी हो गई जिसमें मुझको जो है स्प्लिट पर्सनालिटी है या फिर सीजर्स आते हैं मुझको, आई बिकम रेज्ड एंड वायलेंट. All those things, in that case I'll be exempted. Suppose a person is schizophrenia है उसको, and because of certain seizures that I have, I simply kill people. है ना? I kill people because of the seizure. Kill people because I completely have lost the control over my mind. That can also happen. है ना? There is a very interesting case of there is a serial killer in America, Billy Milligan. है ना? बहुत बिली मिलिगन करके है, जिसके स्प्लिट पर्सनालिटी डिसऑर्डर का एक वो केस है. दैट्स वेरी इंटरेस्टिंग केस, है ना? तो वहां पे कैसे वो डिफेंस लेता है. देयर इज अ नेटफ्लिक्स सीरीज अबाउट इट, 26 फेसेस ऑफ बिली मिलिगन, ऐसा करके कुछ सीरीज है, वो भी देख सकता हूं. वेरी इंटरेस्टिंग. Similarly, there if something is wrong with someone's mind, obviously one can say there is a lot wrong with the mind of a serial killer. एक serial killer है, टेड बंडी है, serial killer है. वो लोगों को रैंडमली पकड़ता है और he kills them randomly, है ना? Without any motive, he kills strangers. Obviously, something is wrong with that person's mind. But because what he has wrong in his mind, his medical insanity does not become legal insanity, because whenever he kills people, he tries to cover his marks. Means he tried to hide his crime. It means he is aware that what he is doing is wrong. अगर आप कुछ गलत नहीं कर रहे हैं तो आप छुपाएंगे क्यों? और अगर आपने छुपाया है, इसका मतलब आपको पता है कि आप क्या गलत कर रहे हैं. So if you are aware about the wrongful nature of your act, it means that you are not legally insane. Because you will not, if you are doing a legal lawful act, well, you'll try to hide it. So proof of insanity is from surrounding circumstances. A person will be taken, tested for medical insanity. At the same time, it has to be proved in the court of law that this medical insanity was the primary factor behind this act. जो भी क्रिमिनल एक्ट इन्होंने किया है वो इसी इंसैनिटी के कारण किया है. कोई व्यक्ति नींद में चलता है और नींद में चलते हुए उसने किसी को मार दिया, उसकी लायबिलिटी नहीं है, बट ही विल हैव टू प्रूव कि जिस समय वो नींद में, जिसमें वो उसने एक्ट किया वो एक्चुअली नींद में था. And that has to be proved from circumstances. So there are n number of things you can see and watch. So insanity is a very interesting thing by that particular standard. It has to be proved by the defense. Positive evidence has to be given that there was a medical insanity, and not only this person was insane, he was insane in respect of that particular crime he has committed. If he was insane but sane in respect of crime, liability, yes. If he was generally sane but insane in respect of one particular act that he has done, in that case that person will be held not guilty. So that is what we call insanity. So I hope some clarity you have in this particular issue. This is called defense of insanity or unsoundness of mind. Mental health act है, इस पे वो भी कुछ काम कर रहे हैं, but this much I believe will be sufficient for you to understand. Okay. So thank you so much. Next we'll learn necessity, intoxication, consent, and triviality. Going to be a big lecture. So thank you so much. I'll see you all in the next class. If you have any doubts, my email ID is there on the screen. Please write me a mail. Thank you so much. I'll see you all in the next class. Thank you for being patient listening.